We now have the team at Duncan Cotterill covering the essentials of when it comes to the legalities of running a small to medium business. We know this can be a minefield, so we're grateful to have a very experienced selection of the team here today. Talking you through the key essentials, we have Kirsty Wallace, a specialist in employment and health and safety law, Nikki Robertson, a specialist immigration lawyer, Hamish Walker, who leads the Duncan Cotterill National Franchise Practice, Nick Crang, with a number of law specialities, but we'll touch on fair trade today. David Briscoe is a member of the National Private Client Team and will be talking in the property space. So you can see we are well covered on some critical topics for food and beverage businesses. Over to you.
Hi, I'm here to cover the employment law aspects. My name's Kirsty Wallace. So basically, everything that you'll need to know comes down to good faith. All the different legislation that I'll go through in some detail comes down to common sense. How would it feel if I were in their shoes? And generally that comes back to the term of good faith. Sorry. Individual employment agreement. The fixed term one I know pops up a lot, and the key things to work out is if you can have a fixed term employee, is do you have a genuine reason for that being a fixed term? And then your actual employment agreement needs to cover that off. So for example, you can't just say, oh, the funding relates to that short period of time. It needs to be quite clear. The other thing to watch out for is if you have someone on continuous fixed term agreements that roll over, if you're giving them an expectation of ongoing employment, you may find it's actually no longer a fixed term agreement and actually becomes open-ended. 90-day trial period. So I know that's something that comes up in the hospitality section a lot. The key things to watch out for is if you're doing a trial period where you're wanting to have someone doing a shift, I've heard a lot about these trial period shifts. Nothing wrong with that, but I'll just take it back a step. If there's 19 or fewer employees, get the employment agreement in with the statutory 90-day trial period before that person starts that trial period shift, and then that way you're covered should you decide it hasn't worked out and they're not going to be someone that you want to continue in your business. Absence, medical incapacity. Again, this is another thing that comes up a lot with different hospitality clients. How do you actually work through someone who is regularly not coming up? So the key things is process. Employment law is very process driven, so whether you think it's through someone being misconduct, so they're being naughty for wanting a better phrase, or perhaps it's performance, they're just not where you want them to, do the process. So put out the memorandum, the proposal, what do you think they're doing wrong, get their feedback, and then you can manage how you want, controlling the narrative. Points to consider, is this a one-off type thing if someone's suddenly decided to not show up very often? How long have they been absent for? So most employment agreements will have a clause that will say something like, may terminate if they're not there for 3 days, is generally the amount of time. That doesn't mean you can just sort of, shout for the rooftops once they're not been there 3 days. You need to make an effort to make sure that actually they're not there and they know that you've been trying to contact them. Keeping in mind as well that fairness is another thing that underpins it. So are you treating them the same as you're treating other employees? And it's just that how it looks to other employees if they know that you've treated someone else a bit differently. And also the condition it's caused by work, is there any chance that perhaps the employment circumstances could be related to why they're not showing up? If you can cover that off, fine, but just make sure that those points are covered off okay. Medical incapacity, I could talk for an hour just on this issue, so I'm just going to skip over it, apart from to say that most of the time, if someone's come to you to say that they're not well, there's obviously the 3-day period before they need to get a medical certificate, and I'd really encourage you, if you are considering whether or not to terminate someone's employment for medical incapacity, to get advice. It is an area that you can go wrong on pretty easily. It's pretty complex, and again, those fair fair principles go into it, but just look at what medical evidence you have before you embark on going down the medical termination route. Wow, we're ripping through it. Disciplinary proceedings. So again, it's that fair process. So no matter what it is that that you think someone might have done, keep in mind that if there's any disciplinary issue, it's an allegation. So it's like your police investigation. It's not proven until they've had a chance to consider. So in all your conversations, it should be along the lines of, we think this might have happened. What do you think happened? The key other thing that you need to have in all your conversations at the start of a disciplinary proceeding is, what are the potential outcomes that you'll be considering? So there's been plenty of employers that have wanted to terminate someone at the end of a disciplinary process and haven't been able to because they weren't clear that termination could be a possibility at the start. Look at the individual employment agreement. So you can follow a fair process, but you also need to check, well, is there anything in the employment agreement that specifies what process I need to be following? Because you can be rest assured that someone might not be happy with what you're doing or allegations you've put forward, but they're going to read their employment agreement to see what you should be doing. Other things that you consider case by case. So perhaps it's a written warning type situation, perhaps it's a demotion or dismissal, but that's another thing that you need to be getting feedback on at the start. So first of all, put the allegations to them, get their feedback, and then you need to be saying, look, what consequence do you think? You can put it in their court. What do you think should be the appropriate consequence for the findings that we've made? Employment law is always about what's fair, what's justified. It's covered off in the Act. So just make sure that you can actually say, have I followed a genuine reason? Can I justify what we've done? And is the process that we've followed fair? So is my reasoning okay? Is the process I've followed fair? I'll skip through that bit. Suspension. So you might have perhaps someone's stolen some money from the till or something, and you don't want them in the business while you're investigating the allegations you're putting forward. You can suspend someone, but there is an abbreviated process where you actually need to get their feedback on whether they think suspension is appropriate. That can be just a few hours. It doesn't have to be ongoing, but you do need to actually sit down with them, tell them that you're thinking about suspending them, and ask them what they think about that potential. It doesn't mean you can't do it, it just means you need to put that consequence to them. So, disciplinary meetings, the key areas that people go wrong and need to watch out for is, first of all, have you given them a chance to get advice? They don't have to get advice, but have you given them a chance? Have you given them a chance to actually consider feedback or provide feedback to the allegations? And thirdly, have you given them a chance to have a support person with them? That support person can be someone who they want to. It's up to them, their choice. The other thing I had come up with the other day was someone wanted as a support person a colleague. So then it becomes quite awkward for the employer, and that's just a case-by-case scenario. Restructuring, similar kind of thing. Get advice if you're considering it. It's very much process. The key themes to have in any restructure discussion is, this is a proposal, we want your feedback, we haven't made a decision yet. And if you stick to those three key themes, you should be okay. Should. Personal grievances, I'll leave these slides here because this is another key minefield, but the key things to think about are those different fair process that we've talked about, and be reasonable, be transparent. If someone's is still employed, then it could be disadvantage. Have they been disadvantaged in their employment? If they have left, then it's dismissal, and the compensation amounts can be quite big, and often you'll need to make a commercially pragmatic decision, which is not always fair as an employer, but sometimes it's about how can we be commercially pragmatic to essentially make the issue go away. And I'm going to skip through these. Holidays Act, that's the final one. So there was a task force with both political parties earlier on in the year. They made 22 different recommendations to the Holidays Act. Labor has indicated that they've run out of time before the election, but given that both National and Labor have said that they want to make these changes, I'd expect to see some changes happen to the Holidays Act after October's general election, so just keep an eye out on that one. And that's me. Thank you very much.
Thanks, Kirsty. My name's Nikki Robertson. I'm a member of Duncan Cotterill's National Immigration Practice. So last year the Minister of Immigration implemented the employer accreditation scheme, so any employer wishing to recruit migrant workers has to hold accreditation with Immigration New Zealand. Once your accreditation is approved, if you want to offer a job to a migrant, you have to go through a job check process. Once that's approved, you can then offer a job to a migrant and they then apply for their accredited employer work visa. One of my colleagues calls it the AWV, which is what we abbreviate to now. Very cool name. One of the things to be aware of is when you apply for an accredited employer work visa is you have to get paid at the median wage, which is increased on the 27th of February to $29.66. There is an exception for the hospitality industry, which is $25 an hour, but I'll talk more about there's another requirement for that. Very quickly, for your employer accreditation, there's 4 types. You've got the standard if you're going to recruit up to and including 5 migrant workers, high volume, which is 6 and above. If you're a franchise, you need to apply for franchise accreditation, and if you're going to be placing employees with a third party, then you also have that triangular option. Key things to be aware about when you apply for accreditation is you have to think about who your key people are. So that's your directors and anyone involved in the direction of the business. The business has to be viable and genuinely operating. And another consideration is whether you've had any instances of non-compliance with your employment or immigration law. So, for example, if there's any past oopsies, I didn't realise that person actually couldn't move into that role with me, you need to think about declaring that and being upfront with Immigration New Zealand. So I talked about some exceptions to the median wage. There are some sector agreements which include pay rates, timeframes and specified roles. Hospitality is $25 an hour, which is currently 90% of the median wage. It is anticipated that will increase in February next year, so one of the things you should think about is, are you going to be able to meet paying the median wage if it goes up in 2024? Now, there is an appendix to the immigration instructions which says if you offer a role to somebody in one of these occupations, the exception to the median wage kicks in, and that does include conference and event organisers, licensed club managers, hotel or motel managers, bar attendants and baristas. So if you're going to offer a job and you think, oh, I'm going to be able to be fine if I'm paying them $26 an hour, you really need to double check whether the role is actually on the list. So then your employee or prospective employee applies for their visa. What do they need to think about? Can they demonstrate they're actually suitably qualified for the role that they've been offered? So I don't know if you're familiar with ANSCO, the Australian and New Zealand Standard Classification of Occupations. It lists all occupations, the skill level, and it sets out what the minimum skills or experience should be for somebody to work in that role. So you need to think about whether your prospective employee can meet that. You need to make sure that the role advertised, that any prospective employer can meet those. And are they bringing any family? And that's relevant because on the 31st of May, there's going to be changes to partnership-based work visas, and that's going to impact on a number of employers trying to attract people to New Zealand if their spouse or partner can't actually get a work visa with unlimited work rights. In terms of your employees or prospective employees, things to think about is understand their culture and the way they like to be communicated with. Kiwis don't like being told what to do. Other countries, their culture is that they have very step-by-step guidance. So understand your employees, provide practical help to your new employees when they arrive, prepare a welcome kit, have accommodation and transport organised, help them with their IRD numbers. That just helps them adjust to what is a big change in their lives. You've also got to provide settlement support information to any new employees within 1 month and allow them time within their work hours to complete the online employee modules. Now, that's the accredited employer work visa, but there is another visa that a lot of employers don't know about, which is the specific purpose work visa. It allows people to come into New Zealand for a specific purpose or event. An applicant must have the skills, attributes and experience to be able to fill the job. And immigration needs to be satisfied that giving them the visa is not going to create any negative impact on opportunities for Kiwis. So one example is that you can apply for a specific purpose work visa to bring in performers who are appearing in a show. So that's a really useful visa, so think about that if you have somebody just needs to come in for a month or 6 months and they can demonstrate they meet those criteria. Okay, earlier this year, as a result of the tragic, the really serious events that hit the Auckland region and then the Cyclone Gabrielle in Hawke's Bay, the Minister of Immigration and the government introduced a recovery visa. And this allows people from offshore to apply for a visa, come into New Zealand quickly as possible to help with insurance assessments, repairing or stabilising infrastructure, building and houses. Now that visa is granted for up to 6 months, and the reason for that is it eliminates the need for a medical certificate, which means the application can be processed so much more quickly. An employer's got to demonstrate that the role supports the North Island recovery. You can't extend the visa, but if you have somebody and then want to offer them a permanent job, you can then go through your accredited employer work visa process, for example, and offer them a permanent job. Those applications are being prioritised and they are going to be done within 7 days. Also, if it's approved, you get the $700 fee refunded. Just very quickly, for some employers who have people working in a job where they can't work on site but they have a location, you can actually move an employee for up to 2 months to work in that second location. And you don't have to apply for a variation. They can go there for up to 2 months and come back. They're not seen as doing anything in breach of their conditions. I would keep very good paperwork on that though, just in case when they apply for a new visa, immigration doesn't suddenly turn around and say, oh, we think you've breached the conditions. And finally, the partners' upcoming changes to work rights. This is due to come in on the 31st of May. The ability to apply for an open, unlimited work visa for a partner of a work visa holder is changing. You can only get unlimited work rights if you are the partner of an accredited employer work visa holder who's in a role on the green list, or somebody employed in a role being paid at twice the median wage. Otherwise, you will get a limited work visa where you can only work for an accredited employer, and you must earn at least the median wage unless the role is covered by an uncapped sector agreement. Now that's going to have a major impact on unaccredited employers, and it's also going to make New Zealand potentially less attractive to bring Kiwis to New Zealand. To bring people to New Zealand if they can't bring their partners and get open work right visas for them.
Morning everybody. So you've got a great business, you want to scale up, what's next? I'm going to talk about some options, run through some of those quickly, and then go into a little bit more depth on franchising in particular. So some of the options, and these are not finite, there might be hybrid options where you combine a couple of them. First one is the status quo, so you've got a successful business, it works, why change it? you might just decide to stick with that, improve on it. It might grow and evolve. I've got a number of clients who have expanded in different ways over the years and then eventually come back and retracted and just had the original successful business. A limitation on the status quo option would be that it's not really leveraging like some of the other options are, and you've got all of your eggs in one basket. The second option is to replicate or become a multi-unit operator. So that might be, instead of having one restaurant, you expand and get 3, 4, 5 restaurants, all of which you might own. You're multiplying your success if you do that. You're spreading your risk and you're retaining control as an owner of all of those. There is a limit to how many you can manage and grow though. As an owner, you might have managers in place, but there's only so much oversight that you can give, and only so many really that can be run well by managers rather than having owner-operators in charge. The third model would be agency or distribution arrangements. A good example of that is the still shop. That's kind of a hybrid distribution license model, but if we look at it from a distribution perspective, benefits there are reach, so you can have a number of units or stores in operation. Typically, you don't use a supplier's full retailing package in that sort of situation, but maybe you are using their marketing brand, so the still shop obviously is a strong brand. You do have less control as the owner of the system in that case, and it's probably a little bit more of a tenuous relationship than you might have in, say, a franchise. The fourth option is joint venture. And that again might overlap with a license or franchise model as well. Typically there you might buddy up with an owner-operator partner who might be the day-to-day operator of the business. This option assists with the spread and growth of the business model or the product or service. As you get into these sort of models, joint ventures and franchises and licenses, it becomes a bit more intricate in terms of the relationship. And so there's considerations there, and also it means, as with any relationship, if there's a divorce, it becomes a bit messier than some of those easier options. The next one is cooperative. A good example of that is Mitre 10, that runs as a cooperative. That provides buying power as a major benefit. Often there's no system or operational control or common procedures, but sometimes there is. Again, this is a bit of a looser tie, but in reality, how easy is it to extract yourself from a model like that, especially if it comes with a strong brand? How easy is it to pull away from that and carry on your business under another brand and do as well? So that's some things to think about there. Getting into licensing and franchising. So franchising is actually a form of licensing. It's easy to get confused between the two models. A good way to look at it is that a license model allows someone to sell your products and use your IP, and in particular your brand. A franchise model is where you allow someone to actually duplicate the business, usually in another location. So just looking at licensing in general, a benefit there is scale and growth. Compared to franchising though, there's less control. That person's not using your full business format system. There's less uniformity and less of a partnership there. Whereas with franchising, if you look at the gold standard in franchising over the years, you'd have to say McDonald's is right up there. That's, as I said, it's a form of license, but it involves the duplication of a business using what is effectively a full turnkey business solution, and it involves a more intense relationship than licensing and some of those other models do. A benefit of franchising is scale and control. But again, if the relationship ends in divorce, that can be a bit more fraught than some of the other models. So if you are going to scale up, what model suits you depends a lot on you, the nature of your business and the product or service. It depends on what you're looking to achieve, how much control you want in the relationship, how much you want to put into it as well. So franchising, for example, requires developing a system. Think McDonald's, the uniformity and all the manuals, everything's done exactly the same way in all the McDonald's stores. There's training involved, there's ongoing support of franchisees. So just dipping a bit more into franchising in particular, everyone's heard of it. How big is it in New Zealand? In 2017 there was a massive survey of franchising done by Massey University here and in conjunction with Griffith University in Queensland. A couple of things that came out of that were, remember this is 6 years ago now, that franchising represents approximately 11% of New Zealand's GDP, and there were over 630 franchise systems in New Zealand and over 37,000 operating units in New Zealand at that time. I don't know what impact COVID's had on that, it's either more or less now. Stats also show that startup businesses under a franchise brand have a far greater chance of success than independent startup businesses. The latter, of course, have notoriously high fail rates, but less so with franchises. There's two main types of franchise traditionally. One is a product and a trade name. Good example of that traditionally is the likes of petrol stations. The more common model that we know and understand well in New Zealand is the full business format model, which is exploiting the full benefit of a successful system and operation. McDonald's is a good example of that again. So how to franchise? What do you do? At a really high level, there's a few key things. One is that you have an established business that can be replicated. There's no good having a startup business and trying to franchise it off the bat, because what's someone buying? An idea, but not something that's proven. Feasibility, so really it needs to be assessed using appropriate experts. There's some good franchise consultants out there who can work out, is it going to be something that can be replicated successfully. You need to document the system in manuals and protect your IP properly if it's not already done. And then you need to build a franchise network of franchisees. So just to finish up, a couple of quick tips and tricks and observations in my experience in franchising over the years. If you're going to do it, go in boots and all. Don't just dip your toe in the water with it. I've seen heaps of businesses that have done that and just got nowhere with it. You've got a far greater chance of succeeding if you do it properly and commit. To do it well, you need to engage appropriate experts. I mentioned consultants earlier. You need an accountant and lawyer who know what they're doing in the franchise space. They'll help you with things like, what's the fee structure? Do you grant a single unit or location franchise, or are you granting someone the rights to develop an area themselves, or are you granting master franchise rights? So does someone get a territory and they get to grant sub-franchises in that territory? All are valid options, but suit different businesses. You need to get the structure right. You need to have your IP protected, probably in a standalone entity that where the IP is safe if something happens to the franchise operating system. You need to have a franchisor entity, and if you're providing or supplying products or services to the franchisees, you'd probably have another entity again that's separate to that. You need to have really good manuals. There's often a correlation between the quality of manuals and how successful the franchisees are. You need to recruit well. There's a real temptation, especially when you set up a franchise system, to grab the first person who waves a checkbook and says they're keen to join. That often doesn't end well. There's a lot of a high proportion of franchise disputes, you'd have to say, early franchisees in a system. But franchisors tend to start to recruit better as they go, with less disputes and falling outs as a result. Finally, a really good resource if you are interested in franchising and want to look into it more is the Franchise Association of New Zealand website. It's got loads of really good resources on there, so it's well worth a look.
Good morning. My name's Nick Crane. I'm going to talk about fair trading and healthy competition. So, fair trading, the Fair Trading Act is that applies here. The key provision in the Fair Trading Act is that no person shall in trade engage in conduct that is misleading or deceptive or is likely to mislead or deceive. Now, it doesn't matter for this if you didn't intend to do that. It's just the effect of the actions that you've done on the public, on customers. And the focus really is misleading, and that's just anything that has a tendency to mislead people, to get them confused or deceptive. It does not, as I said, does not matter if you intend to mislead or deceive. So some examples of behaviour, actions that have breached the Fair Trading Act is charging a higher price than advertised, say on your menu. Let's say, and even that can be through an error. So let's say you even have an error on your menu, and then that's not actually what you intended to charge. That would be misleading conduct. Adding additional charges to the bill. So I know, like I was thinking about the public holidays we've just had, and there's a surcharge there. Now, that's okay if you have a surcharge, if you advertise it in advance, but you'll breach the Fair Trading Act if you haven't told the customers about that in advance and then put it on the bill, and that would be a breach of the Fair Trading Act. Advertising specials when they're not actually available is another way of breaching the Fair Trading Act. One of the ways that this often happens is that people will say we've got a discount, say off the listed price or a normal price, but they actually hardly ever have that listed price or normal price. So when you talk about a discount or a special or something, it's got to be a special off what would normally apply and what would normally apply most of the time. The other things just a couple of things about the Fair Trading Act is there's also provisions that against misleading misrepresentations. So the key thing there is just when you are making representations about your business and the things that you do, they have to make them clear, accurate and unambiguous. And a lot of people fall down on that. And another area that came in reasonably recently is when you're making representations about something about your products or services, and let's say in the food sector, this often happens with products which people think have a health benefit. If you're trying to make a claim like that kind of thing about your product, that it has a particular effect or something like that, you have to have a reasonable basis for that claim and some information to back it up. And the Commerce Commission has been enforcing that kind of provision as well. So the Commerce Act, this is the purpose of the Commerce Act is to ensure that businesses compete properly. So they like to, and it does that for the benefit of consumers. So it's trying to focus on making sure that our markets, competitive markets, which will deliver the most competitive price and service to customers. So the Commission does want you to compete on price and products and service and all those things. The key thing is making decisions on those things yourself, not entering into agreements or understandings that have the purpose or effect of reducing competition. So those are the things that would breach the Commerce Act. When it says arrangements or understandings, they can be not in writing, they can just be a handshake or just a general understanding between competitors in the marketplace. And those kind of really low-level agreements have been found by the courts to breach the Commerce Act and have led to penalties against the people that entered into them. So one of the key provisions we want to talk about is the ban on cartels. Cartels sounds like a pretty cool word, and I know in the hospitality sector it's sometimes used as a brand name. There's a coffee company in Australia called Cotterill Coffee Company, and one in Christchurch, I think, as well. But in competition law, cartels are bad, and the reason they're bad is that they stop the competitive market from operating properly. So these cartel arrangements are agreements, understandings or arrangements that with your competitors that have the purpose or effect of doing three different things. The first one of those is price fixing. So that's where the competitors set the price between them of services they provide in competition. Now, so this might be something like 2 restaurants or 3 restaurants agreeing upon the price of the dishes they offer, or the price of drinks, or the amount of discounts that they're going to offer off things. The second category is limiting the amount of kind of goods and services you provide. So this could be things like how often your venue's open for, the range of dishes or the kind of dishes and drinks that you provide. And the third kind is allocating markets. So which areas of the cities say that you'll have your venues. Now there are some exceptions to this. One of them applies in the for collaborative activities, and that applies in joint venture situations, and also will apply in some franchise situations that Hamish talked about. But if you're starting to get into something that could be a collaborative provision as part of one of those arrangements, then that's the time to get it checked properly. Go and see a lawyer about it. But maybe the first step for this would be to go to the Commerce Commission website And the Commerce Commission website's got some really good information about the Commerce Act and the Fair Trading Act and all that, and how to comply, and some really good videos as well that help you with understanding how these laws work. So that's me, and I'll pass over to David now.
Commercial property leases are important documents. They're long-term binding commitments that for tenants can be the largest investment they make, and for landlords a major asset reflecting a large source of income. As such, they should be given the appropriate time and consideration when being entered into. When entering into a lease, it's important to look at your situation, type of business, and the way you run that business, and then tailor your lease accordingly. Your commercial situation may not necessarily fit the standard form lease. There's also a tendency for tenants to agree to standard forms without understanding the content or being aware of the ability to negotiate terms. As such, I recommend without exception that a tenant seeks legal advice before entering into a lease. There are two main standard form leases in use in New Zealand. There's the ADLS lease, which 90% of all leases are documented on, and the Property Council New Zealand office, retail and industrial leases. For today's purposes, I'm just going to be focusing on the ADLS dealer lease. Under that lease, there are the following key areas for negotiations and areas that are important to get right. So that's personal guarantee limitation, the no access period, liability for outgoings, rent reviews, reinstatement make good obligations, and the premises report. So I'm going to quickly step through those briefly now. So the majority of you, when entering into a lease, will do so under a limited liability company. Consequently, a landlord will generally, in most cases, require personal guarantees from you as directors of those companies. Those guarantees are, as a rule, unlimited, meaning the landlord could pursue you for any and all outstanding amounts under the lease. As such, I recommend negotiating a limited guarantee of either a defined amount or an amount linked to a defined period, for example, an amount equal to 6 or 12 months rent and outgoing. Something else to be aware of with guarantees is that they continue beyond an assignment of the lease, when you no longer have an interest in the premises until the earlier of the lease expiring or the term of the lease being renewed by the assignee. As such, I recommend negotiating upfront as part of the lease terms the release from any guarantee on assignment. So the next area to look at is the no access period. The no access period is relevant if there is an emergency and the tenant is unable to gain access to the premises to fully conduct its business because of safety reasons or the need to prevent any hazard, harm or loss that may be associated with that emergency. If that is the case, either party may terminate a lease by giving 10 working days notice to the other if the tenant has been unable to gain access to the premises for the defined no access period, or the party that terminates the lease can any time prior to termination establish with reasonable certainty that the tenant will be unable to gain access to the premises during that period. As such, the shorter the no access period, the better. The default no access period in the first schedule of the lease is 9 months. However, this is regularly reduced to a shorter period, and I've seen agreed periods as short as 3 months. So outgoings. Where possible, you should limit outgoings to tenancy consumables. These are things like utilities and services, rubbish collection charges, and the provisioning of toilets and other shared facilities. You want to avoid the big ticket items like liability for rates, insurance costs, and cleaning, maintenance and repair charges. If you can't limit the outgoings, you should always seek clarity on the premises percentage or fair proportion of outgoings as against the total outgoings for the building. There's a big difference between being responsible for 25% of 100,000 annual outgoings and 25% of 500,000 annual outgoings. And that may be a factor, that may factor into your consideration to enter into a lease for a particular premises. So rent reviews. The ADLS lease provides for two standard types of rent reviews: market rent reviews that are fixed by agreement or valuation, and CPI rent reviews that are based off movement in the CPI. However, it's important to consider what will work best for you and your business and allow you to budget appropriately. This might instead include fixed rent reviews where the rent increases by fixed and therefore known percentages or amounts. In the event you do go down the market rent review path, the CPI rent review path, or a mixture of both, I recommend you consider negotiating a maximum cap on any potential rent increase. Most of you are probably aware of what MBS means. For those that don't, MBS means new building standards, and all new buildings are built to 100% MBS. However, while the building code has improved and changed over time, buildings haven't necessarily had to. This has resulted in many commercial buildings, especially in Wellington, now having MBS ratings well below 100%. Practically, this means those buildings will be susceptible to damage in a seismic event. In the event you're considering a lease of premises that are below 100% NBS, but at a level you are comfortable with, I recommend negotiating the insertion of a seismic warranty that obliges the landlord to keep the NBS rating and not let it fall below that same agreed level, and provides you with the ability to cancel the lease in the event the landlord's unable to keep it at that level. A consequence of such a clause is that the landlord may require you to vacate the premises while it undertakes those strengthening works, and that could obviously cause disruption to your business. So in general terms, the tenant is responsible for maintaining the interior of the premises and the landlord the exterior and the building services. The tenant also has the primary obligation to maintain the landlord's fixtures and fittings. However, any costs covered by the landlord's insurance policy cannot be borne or passed on to a tenant. But it's worthwhile noting here that premiums and excess payments are outgoings payable by a tenant if not expressly deleted. As part of a tenant's maintenance obligations, it's required to repaint and redecorate the interior of the premises and replace any worn or damaged carpets. Additionally, if a landlord has authorised any alterations or additions which were made before the commencement date or during the term of the lease, the tenant must at its own expense, if required by the landlord, reinstate the premises to the state the premises were in prior to the alterations or additions. Obviously, these redecoration and reinstatement obligations can be costly, and as such, I recommend negotiating the deletion of the redecoration and replacement obligations and amending the reinstatement obligations or provisions so that you're only obligated to leave the premises in a clean and tidy condition unless you elect to remove your fit out. So the last thing I wanted to touch on were premises condition reports. Premises condition reports now included as a standard schedule in the ADLS deed of lease. This is useful to avoid make good or reinstatement disputes at the end of a lease, but also for documenting ownership for insurance purposes. However, for whatever reason, tenants widely underuse this and don't complete them. There's no particular form that needs to be used. It could be a written report, photographs, or a mixture of both. But I certainly encourage you to include a report as part of any lease that you enter into. So, to sum up very quickly, standard form leases are a base only and they should be used with caution. You should consider your commercial circumstances and modify the lease accordingly to fit those circumstances. You should discuss the lease and the critical clauses in that lease with your lawyer, and where possible, negotiate more tenant-friendly positions, including those I've outlined briefly today.